Welcome to the 13th episode in the first season of Justice Center Weekly, the video cast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me is lawyer Hatim Kheir, who is here to tell us about a new Justice Center case just filed against the Parliamentary Protective Service on behalf of a pro-life organization which was prohibited from displaying certain signs during a protest last May. Welcome, Hatim, and get us started here. When was this filed, and what is this all about?
Well, this was just filed last week on Thursday. Basically, what's at issue is that Campaign Life Coalition every year organizes the National March for Life in Ottawa. And this year, they did the same. They organized the march, and the day before, they were going to have a press conference. Well, they did have a press conference, and they invited the press to come and attend, and they planned that they would reveal signs in the middle of the conference, and these are signs which depicted victims of abortion at different stages of development. Now, as they were preparing for the press conference, they were dealing with the Parliamentary Protective Service, which is normal. There's different kinds of permits and rules about the use of the Hill in terms of the use of stages, etc. And all was fine, but as they were preparing, an officer from the PPS came and asked to see the signs, which were laying down on the lawn. And when they showed it to him, after conferring with his superior, he came back to inform the people with Campaign Life that the signs were too graphic, and so they weren't allowed to show them on the Hill. Campaign Life complied. They swapped out the signs for different ones without images, but just words. And the press conference proceeded. And then after the fact, the officer from the PPS emailed to provide an excerpt from a policy, the rules for the use of the Hill, which prohibited having signs which promote hatred, which contain obscenity, or which are offensive.
And what did they say the signs contravened?
So he didn't specify further, though the terms promotion of hatred and obscenity are actually defined terms. So they're criminal offenses.
Okay.
Promotion of hatred is defined by the Supreme Court as material which is designed to incite intense feelings of vilification towards a particular group and other people. So that is a limit on freedom of expression. It's been upheld by the Supreme Court because it's narrowly tailored. Likewise, obscenity, it relates to material of a sexual nature, but which also has an element of either extreme violence or a degrading nature to it. Again, it's a crime. It's narrowly defined, and it is upheld as a constitutional limit on freedom of expression. The images in this case didn't meet either of those definitions, so presumably it was because it's offensive, which is quite a broad term and not one that is technically defined.
So in this filing, you're going to get them to specify what they found offensive about this, or do they have to defend themselves, or? Well,
the way it works is there's a limit on freedom of expression that's at issue here, so the question then becomes whether or not it's demonstrably justified. And right. In terms of that demonstrable justification, the onus does shift to the government to show that it is a justified limit. So part of that will be explaining what the limit is and why it's reasonable in this case.
So what they're saying is causing offense is demonstrably justifying their limit on free speech. Is that their position, if I can put it in
Well, we don't have their position yet. This is the beginning of the case.
Okay.
And there is one extra wrinkle that I left out of my summary. So that was the policy that was provided by the PPS officer. Right. However, the policy was actually changed about a week or so before the press conference took place. And so the officer was providing an out-of-date version of the policy. So the policy has been changed. It still prohibits the promotion of hatred. It still prohibits obscenity, but offensiveness has been removed, and it's been replaced with a prohibition on signs which depict excessive violence or blood.
Or blood. Okay.
Yes.
Again.
So these images do depict
Right.
blood, so it would also fall under that. So the challenge we're bringing challenges the old policy, because that's what was relied upon, the new policy, because that's the one that was actually in effect, and the decision itself and the way it impacted the rights of Campaign Life Coalition and the individual who's going to hold the sign.
Right. Using that definition of just blood, I mean, a newborn baby would be offensive according to the Parliamentary Police Service.
Absolutely, and it's still quite broad. It captures a lot of things that I think people abortion is a divisive issue. People have their different opinions on it, but there's lots of things that issues where people probably wouldn't disagree that would get captured by this. So, for example, someone who wanted to protest, or maybe not protest, but raise awareness about the Holocaust and the people who suffered during the Holocaust. They may want to show an image that depicts that reality in order to make their point, much like the individuals from Campaign Life were trying to do here. And again, that may show blood, that may show violence, and because that was the reality of that historical event, but that would be captured by this policy.
Right, as any genocide probably would, like the Rwandan genocide. I've seen images from that, which are fairly graphic, and something like that would be captured by this law, or this. It's a policy, right? It's basically a policy.
Yes, it's rules for the use of the Hill, and it covers lots of other things that have nothing to do with freedom of expression, sort of mundane things about the size of stages and that sort of thing.
Who creates these rules? Is it the service itself, or is it passed by Parliament, or what?
Well, that's the not sure about that yet. So that'll come out in the litigation. It's the rules for the use of the Hill. Now, the Parliamentary Protective Service is an interesting organization in that they're not equipped with police powers the way the RCMP or the Ottawa Police are. So they're tasked with the security of Parliament Hill, and if they detain someone, they pass them off to the Ottawa Police, for example, to be processed. Now, the Parliamentary Police Service in turn reports directly to the Speaker of the Senate and the Speaker of the House of Commons, and so they jointly have ultimate responsibility for the PPS.
Right, and if I recall correctly, weren't they created in the wake of that attack, one-man attack on Parliament Hill?
Yeah, I believe so. They're a pretty recent creation. So, and there isn't a whole lot of litigation involving them either at this point.
Okay. Are you looking to use any precedents in this situation?
Well, of course, there's plenty of precedents that govern the law about freedom of expression, and that's what's really at issue here. Okay. The question is, were the Campaign Life engaged in expression? They were trying to convey a meaning. Was there a limit on that expression? Again, there was. They were prevented from conveying that meaning. And then what it comes down to is whether or not that limit is justified.
Okay.
So in terms of some of the jurisprudence that's out there, for example, there was recently a case a couple years ago called Ward. So what happened is there was a comedian in Quebec who was fined by their human rights tribunal for making jokes about an individual with progeria. And he was fined. He appealed it all the way up to the Supreme Court, and the Supreme Court ultimately overturned that fine, finding that it unjustifiably infringed his freedom of expression. And the court had a lot of useful things to say about the limits of freedom of expression, what is allowed and what's not allowed. And they were pretty clear that people are allowed to be offensive. People don't have a right not to be offended. People don't have a right not to have their feelings hurt. And sort of the flip side of that is that people do have a right to offend. That's included in their right to express themselves.
This actually, I guess, is supported by the fact that they took out the offensive part of, or they amended their policy to take out that offensive portion of their policy.
Yeah, it does seem like someone on their end probably saw that, recognized that it was too broad. It was very clearly not constitutional, and so they changed it to to try and tailor it to address presumably what kinds of images that they didn't want conveyed.
Okay. I wonder if there's any evidence that this was an attempt to deal with the protest that was imminent, because it sounds like it happened just before the pro-life protest.
Yes, so the March for Life did proceed. People weren't prevented from having those signs on the street. So the march it happens on the streets of Ottawa. So it's now outside of the jurisdiction of the PPS. So there is no law, generally speaking, against having an image depicting a victim of abortion, the exact same signs that in this case they wanted to have at the press conference. Where these signs do come up is there is precedent about advertising. So city advertising, people, bus shelters or on the sides of buses, that sort of thing. And pro-life groups have in the past run ads depicting the victims of abortion, and then they were initially allowed to run the ad, and then the city turned around and prevented them, or in some cases they weren't allowed to run the ad at all. And there are cases upholding that decision to prevent them from running the ad, finding that it was a reasonable limitation on expression given the function of, for example, a bus shelter or the transit system. Now, what's different here is that this isn't it's not a city bus shelter. It's not a city bus. These are signs that the Campaign Life had. They were going to hold them up. It was going to be at their press conference. The only thing is they were going to be on Parliament Hill. But unlike a bus, Parliament Hill is it's almost the perfect example of a public square in our society. Parliament is the seat of the federal government. But it's also a symbol of government itself, and so that's why it's an important place for people to be able to go and protest and make their voice heard.
With as few limits on freedom of expression as possible, I think that's what you're implying.
Exactly. Yeah.
Okay.
Yeah.
All right. Just curious, would this policy apply to members of Parliament themselves? In other words, does it apply inside the House as well as on? Because it's supposedly the grounds of the Parliament. And so that would be inside the House and out, wouldn't it?
Likely not. So the rules are for the use of the Hill. So it's specifically about people wanting to gather on the lawn in front of Parliament.
Okay.
It is a regular place for people to gather in protest, and so it's pretty frequent that people want to use the Hill for one event or another. And so there are rules about what can be done on the Hill, what. Again, it covers a wide variety of things. Like, for example, if you want to set up a stage for your event, there's rules about that. But where they venture into the limits on freedom of expression is when they start to talk about signs, and there's certain rules about the size of a sign. That's probably permissible, just because it's not going after the content of the expression. It's just trying to regulate the way it's conveyed. But then it goes beyond that, and it does create rules that specifically govern what a sign can show, and that's where it veers into restricting certain kinds of meanings that can be expressed.
Oh, I see. Okay, to the format of the filing itself in the court jurisdiction, where exactly was this filed, and what kind of remedy is being sought, etc.?
So it was filed as an application in federal court.
Okay.
This is the it's the Parliamentary Protective Service. It's a federal entity, so it's being challenged in federal court. It's an application, and what we're seeking is a declaration that those elements of both the old policy and the new policy are unconstitutional, that they contravene the right to freedom of expression in a way that's not justified, and also that the individual action of the officer from the PPS on that day limited the freedom of expression of the group, Campaign Life Coalition, and also of the individual that was going to hold up a sign. Was
it just one individual that is being?
There were a number. There was it was going to be a row of signs that
Okay.
depict victims of abortion at different stages of development. But for the sake of an application, there is one individual who is coming forward to bring this application as a co-applicant along with Campaign Life Coalition.
Okay, is that an organizer of the event? Is it that person named?
Yes, she's an employee with Campaign Life, and she was going to be involved in the press conference, and she would have held up one of these signs had they not been prevented the way they were.
Right. Actually, as you were describing that to me, I remembered another case recently, and this was the right to be offensive. It was regarding the use of the middle finger. And I think that was out of Montreal, a case recently. I guess that supports the right to be offensive. The judge had ruled that, you're allowed to do that without somebody seeking remedy. I guess that type of thing would apply here, or no?
Well, offensiveness is often actually used by the court as an example of an impermissible limit on freedom of expression. So
Right.
In cases that deal with hate speech, for example, like the 2013 Whatcott decision from the Supreme Court, which dealt with human rights legislation that placed limits on expression related to the promotion of hatred, the court is generally pretty consistent in that they'll say, in upholding one law, they'll say, okay, well, it has a narrow application. It's prohibiting this, it's prohibiting the promotion of hatred, for example. But it's not an unjustifiable limit, because what it's not doing is prohibiting things that are merely offensive. And the court, in Keigstra and in Whatcott, goes to lengths to delineate between genuine promotion of hatred and offensiveness. And that same thing applies to other areas of expression that may be regulated or attempted to be regulated by the government. Where they go too far is where they're not combating a legitimate harm, but they're now trying to address speech merely because it's offensive, or merely because someone could have their feelings harmed or may have a negative emotional reaction to it.
Okay, well, you mentioned that your filing is going after both policies. That is the one that was rescinded as well, which included the offensive part. That's kind of why I was asking about it previously. Is that a technicality that you're using there? You just want to go after both halves in case they tried to split hairs about when it was applied, or is there a real reason to go after the old policy and the new?
So in the launching of litigation and informing pleadings, generally speaking, you want to have a broad net, because down the road it's too late to change course.
Okay.
And so in this case, it's a bit of a weird circumstance, because the policy that was relied on was not the policy in force. And so, yeah, as a matter of, just to be safe, it makes sense to challenge both, and whichever ends up being the one that there's a few... There's really three options here. Either this was because I should take a step back. So a limit on the freedom of expression, for it to be allowed to exist, even if it's demonstrably justified, it has to be prescribed by law. So only limits that are prescribed by law and are demonstrably justified are constitutional. So if a police officer doesn't like, you're wearing an Aerosmith shirt and he doesn't like Aerosmith, and he comes up and tells you got to get out of here, I don't want to see that here. That's not a limit that's prescribed by law, and so that would be it's just an unjustified limit on your freedom of expression. And so for this to be prescribed by law, presumably the law that prescribes it is the policy, the rules that govern the use of Parliament Hill. So is it the old policy that was relied upon by the officer? Is it the new policy that existed and, presumably covers the kinds of expression that were at issue here, but wasn't relied on by the officer? Or the third option is that the officer, in making his mistake, actually did something that was simply not prescribed by law. He relied on a law or a regulation that doesn't exist. These rules weren't in force, and so his decision was simply without. It wasn't backed up by any existing law, and so it's unconstitutional for that reason.
Well, you used this term prescribed by law, and that's what I was going to take issue with, and then I realized you may be just using that as a phrase, because these are not laws, as you say. These are policies, and we don't really know how they came about at this point. Am I splitting hairs here when I question whether these are, prescribed by law? Does that include policy?
It does, but you're not splitting hairs. These are things that actually were settled by the court in the past, and they had to be argued out in order to get to an outcome. So prescribed by law is a specific phrase. I'm pulling it out of the charter.
Okay.
But what that means has been decided by the Supreme Court, and so it goes beyond a literal law passed by Parliament or one of the provincial legislatures. It includes regulations that are passed, for example, made by the Governor General or Lieutenant Generals, or by a minister or some sort of a regulatory body. So all those count as law in that they are they're defined they're in text, they're codified. There's something that can be referred to very specific in a very objective way.
So it's not limited to democratic law. That's what I was wondering, because of course,
yeah, exactly.
We went through the whole pandemic, and there were all kinds of regulations being hurled at the people of this country, and they weren't necessarily passed by Parliament. That's why I was.
That's actually a good comparison. So, for example, here in Ontario, there were lockdowns that were made by regulations passed by the Lieutenant Governor. In other provinces, there were regulations that were the form of a public health order made by a chief public health officer, who is a public officer appointed to a role by government. But in each case, these aren't laws passed by the legislature. They were regulations created by some figure pursuant to a legislation. And then where these regulations limited something like, for example, the freedom of religion by preventing people from going to church, the question was, okay, they limited the freedom of religion, but then was that limit justified? And they get to that step because it was prescribed by a law, not legislation in the formal sense, but a law that was codified and applicable to a wide body of people.
Was that controversial when they ruled in that regard? Because I can see it being. I don't recall a case that it was ruled upon, and I assume it was since the charter that they came up with that definition that broadened the nature of law. But it seems to me that would have caused a little bit of controversy at the time, because now anything can be considered a law that can circumvent the charter.
It's before my time, so I can't comment on whether it was what the reaction to it was, but it was something that had to be debated out. There was lawyers that were arguing, and I think it's probably a reasonable position to say that a regulation isn't actually prescribed by law. And maybe this is veering a little off topic, but what's interesting about that is the French version of prescribed by law refers to une règle de droit. I can't pronounce French, so my apologies, but it's a rule of law. So that almost makes it seem like maybe it does have to be the higher standard, and it does actually have to be a formal form of legislation that was passed by Parliament or one of the legislatures, but ultimately that's not what the court decided.
Okay, even though it reads like that in French, and I assume you're referring to Quebec, not France, it has the same interpretation in Quebec. That's all. I just want to.
Well, the French version of the charter is as official as the English version, and so there's a rule of interpretation that where the French and the English are maybe a little bit different, the court should go with the more specific definition or the more specific meaning of the two, and so. One argument is that the French version here is more specific, but ultimately that's not the way the court came down on it. So regulations can, if they're justified, limit people's charter rights.
And that can't be relitigated? Just hypothetically speaking here,
Well, it's a high bar to get the court to overturn its precedent. There has to be some sort of a change in the law that now affects this, or perhaps new evidence, which would be difficult for something like this, where it's not really an evidentiary issue. It's more of a more of an abstract legal question.
Okay.
So, for example, a case where the Supreme Court did change its mind is, for example, prostitution, or another example would be the medically assisted suicide.
Mm-hmm.
So in both those cases, there was previous Supreme Court case law that upheld the limits on those things, and then subsequently it reversed course, a couple decades later, and it overturned those limits. And its rationale for doing that was the social science has developed to reveal that these laws are no longer justified.
Okay, yeah. I suppose I should explain the reason I was asking, because, of course, I was thinking about the various lockdown challenges to the authorities that had come up with these regulations, and their lack of democratic oversight became the issue. And so that's why I was wondering about the challenge to them and whether it can be overturned at all.
I suppose one way to think about this is that the prescribed by law bit in Section 1 of the Charter, it's not so much concerned with the democratic side of things.
Right.
It's more concerned with the rule of law side of things. It's more concerned with the idea that this be codified, that if there's going to be a limit on someone's rights, that it's written down somewhere, that the court can, it's made in advance, that the court can look at it, that the court can decide whether or not it's, the court can look at it objectively and decide whether or not it's reasonable, unlike, the arbitrary decision of a single officer or official.
Right, but it comes down to their interpretation a lot of the times anyway, as in, what is offensive. I guess that's why they changed it to get very specific in this sign case, which was blood, and what was the other one? It was
excessive blood or violence.
Or violence. Okay, right. And we have no response yet, so we don't know exactly what they are going to claim at this point.
Exactly. This litigation is just at its early stages. It's just been launched. But hopefully we can proceed with it quickly, because, the March for Life happens every year. And so, the sooner we can get a definitive answer from the court, the sooner this issue can be settled for not only the March for Life going forward, but really other protesters who want to use Parliament Hill to make their voice heard as well.
Okay, good. Well, thanks for filling us in on this new case, and good luck with it. Thanks a lot, Hatim, for coming in and giving us a bit of your time to explain the ins and outs of this new filing. Thanks a lot.
Thank you.